Welcome back. Here with us on Urban Debate. The centre has told the Delhi High Court that it would need more time to formulate its stand on marital rape in response to the case challenging Exception 2 in IPC Sections 375 that protects men who have forced non-consensual intercourse with their wives from criminal prosecution under Section 376 of the IPC. Centre had earlier told the High Court that it was contemplating a constructive approach to the issue of criminalising marital rape. At the same time, it also informed the High Court that it had sought suggestions from several stakeholders and authorities on comprehensive amendments to the criminal law. The arguments in this case will continue tomorrow. But let us now try and understand what the legal luminaries have to say about this very, very important issue. Joining me on the show tonight is Pinky Anand, senior advocate, former ASG. Thank you very much, Ms. Issue of marital rape. Should it be criminalized?
I think it's high time, Heena. This matter has been going on for a number of considerations, and it has been the subject matter of immense debate as far as gender inequality is concerned and the discriminatory practices that are being continued. I think we were at an antiquated statement of what personal laws were about. And because of that, something which was a crime was made to be not a crime or not an offense. So it's high time that actually this issue was addressed, and it has been taking the attention of the Law Commission, the various commissions that have been organized, the National Commission for Women, the courts. And I think civil society has come to a point where expression is being made about this, and it's something which needs to be considered and acted upon.
Ms. Pinky Anand, while most countries in the world actually see marital rape as a criminal offence, why, in your opinion, India seems reluctant to move in that particular direction? Why is it among 36 countries in the world which have not criminalized marital rape so far?
I think this flows from an idea of romantic paternalism of sorts. This has been a kind of theory which talks about not invading the institution of marriage. I think the basic viewpoint that was taken why marital rape was not made into an offense. In fact, what happened is the law made rape as a general offense. An exception was created to keep marital rape outside the purview of the provision of 375 IPC. Now, that exception was created possibly with the perspective of feeling that marriage is something that should not be intervened in the public domain as in criminal domain, as in the state participating, because it's really between the parties, and therefore it should be a private space. And the sanctity of marriage, which has been something which India, of course, stands for and continues to stand for, is something that was utilized as a kind of cloud to say that marital rape should not be an offense. But as I said, that is something which is, seen progressive dimensions. We've been progressing in most directions, and gender inequality seems to be rampant with the marital rape. Something which is an offense simply because you're married. The offense doesn't go away. That doesn't become, or nobody becomes entitled to a sanction to do something which is otherwise a crime. I mean, for one of the examples given, as you must have heard, is that if 5 minutes before marriage somebody rapes a woman, it is rape. But if you get married within 5 minutes, after that 5 minutes, it stops to be a rape because you've got married to the person. I think also in the same light, actually, Heena, if you see the independent thought judgment of the 2017, Justice Lokur's judgment, the question was whether there would be statutory rape between 15 to 18, because ultimately only under 15, if the person was not your wife, was it considered statutory rape. That exception was considered by the Supreme Court, by Justice Lokur as judgment, and ultimately it was read down. So it was read, 15 was meant to be reading as 18. So statutory rape would happen whether you were under 18, and it would continue like that. The 15 demarcation that was drawn was taken away. And the reason was, again, human dignity, women's dignity, ensuring that they are not misutilized. The idea being that an offense continues to be an offense, and the similar principles were utilized for this purpose.
Back in 2006, you had said that marital rape should be treated as a crime. And we are now speaking in 2022. Nothing really has changed on this particular matter. As former ASG, how will you like to react to the response of Centre in this particular case so far? Because, you know, on Friday, we did see some hope.
Let me be fair, Heena. Whenever there is a changeover and a change of perception and a change of attitude, a change of concept, a change of horizons, you can't say it'll happen overnight for sure. I know the need is very high that this should happen as soon as possible. But the center has taken an approach to say a consultation process. And in fact, just between you and me today, there was a process of the National Commission for Women, in fact, undertaking a consultative exercise based upon what the government had asked, the Home Affairs Ministry of Home Affairs had asked. So therefore, this entire process is something which does require consultation whenever we do things. And believe me, I do understand that when we have a changeover of law, when you do a matter in a court considers it from the constitutional viewpoint and from the viewpoint of whether it's arbitrary, whether it's discriminatory, whether it is anti-women, anti-gender, and can actually construct and strike down a statute straight away. But when you do have a consultation process as far as the government is concerned, you do require to put in a thought to it. So simply because the matter has come up now and this issue has been raised, the fact that the government has taken an approach to say, a progressive approach to say, a consultation process will ensue itself is demonstrative of the fact that there is thought behind the process. And also, I will put it at the end of the day that in any case, the matter is subject to the court's consideration. So if the court considers that whether the government wants to criminalize or not criminalize the marital rape, it is open to the courts to take an interpretation which would make marital rape an offense.
Ms. Pinky Anand, this case has been going on since 2015-16. In 2017, when Centre came out with its affidavit, it had a post-criminalization of marital rape. And now as the hearing is going on, it is seeking more time. Do you think Centre is dragging its feet, or now with the statement that has been made, a more consultative approach as it is planning to take, do you see hope?
I do see hope. I do see a lot of hope, and I don't think a few days is dragging one's feet. Yes, it could. It did withstand as far as time is concerned. You did have the matter going on for some time, but at the same time, it did remain on a back burner. So whenever issues come up in the forefront, I'll just share with you, for example, as a matter of statement, in the triple talaq case that we had done, as you know, the center actually opposed the practice of triple talaq and said that it is something that should be struck down. That was the approach that the center had taken in triple talaq, because the practices were derogatory and demeaning to women and basically were against the constitutional provisions of whether Article 14, 15, 21, right to life. So therefore, the process of consultation doesn't mean dragging feet. However, yes, it is a need of the hour and it needs to be considered as soon as possible.
But ma'am, this process of consultation can't go on forever. The buck really needs to stop somewhere, isn't it?
Yes, the buck needs to stop, definitely. As I said, the buck needs to stop and needs to stop yesterday. But at the same time, I do believe that when we are thinking about amendment of law, some law that has remained on the books of the statute for a considerable period of time, and we do want an amendment to it, or we want a change, or we want to strike it down, or then to do away with it. Ultimately, it does take some process, and it should take some process. I don't think law should be made overnight either. If you need a change in law, it is something which requires a process, and in fact, we should encourage that process. I think this much time we do have to wait to say let the process be considered. But yes, there must be a timeline to it, and ultimately, a decision should be taken whichever way as soon as possible.
Do you think it's about time that courts now criminalize marital rape with the way situation is?
Well, it is always open, as I said. Once the matter is before the courts do not need the sanction of the government to take action. The courts are required to look at the constitutional viewpoint and to see whether the marital rape exception under 375 IPC withstands the scrutiny of law and the Constitution. If it doesn't, it is open to the courts to strike it down. And in this case, what would be considered by the court, what is being considered by the court, is the exception. So you have rape as an offense for all under 375. You have an exception 2, which exempts marital rape from the purview of rape as an offense. So if the exception, for example, is held to be unconstitutional, then anybody raping a woman would be guilty of an offense of rape.
Now, I want to remind you of a case in 2015 where a petition of a woman was dismissed by the Supreme Court saying that, law can't be changed for one woman. Why has it remained a grey area so far, especially, among judges within courts?
I'll share with you, Heena, ultimately, all said and done, judges are human too. And judges are part of the society in which we belong. The notions that are prevalent in society are something which pervades as far as the courts are concerned and the judges are concerned. These are social concepts. So you really have to talk about judges who are looking into the matter are having to consider the various viewpoints that have been existing for a considerable period to say that the institution of marriage should not be interfered with lightly. So believe me, whenever personal laws, whenever personal situations are taken into account, it takes court quite a while before the courts can ultimately bring themselves to the task of really coming down to the consideration. But once the court considers the constitutionality, rest assured, there isn't almost any impediment to the exception being struck down on the ground of unconstitutional provisions.
Now, you're right when you say these are social concepts. So let me ask you, even if a law comes, even if the courts decide, will that change the society? Will that change the mindset in the society towards this issue?
No, you're right, Heena. It takes a lot for people to change and the mindset to change, the perceptions to change, the value systems to change. So you'll have a lot of aversion to the law being changed by itself. And if the law is changed, ultimately you will still find resistance. So you find that across board. I'll give you an example. When there were changes in the Hindu Succession Act, which entitled women to become co-partners and have equal rights to boys or men and claim their rights in properties, ancestral properties in that respect, how many women have actually gone for that contest? Not many. But times keep changing. When dowry demands became an issue way back in 1960s, I'm sorry. Even at that time, not many people registered that as an offense. So you have to have the mindset of society being changed because the criminal system can, in some cases, of course, be invoked without the complainant directly going. But in most cases, it is the complainant who's to initiate the process. So let me give you an example. What you do have and you will have situations where women don't want to register cases of marital rape. It can't be mandatory. It has to be a matter of choice whether a woman actually wants to take up a criminal complaint for the offense of marital rape if the same is made as an offense. So the whole question of how many people would actually go in for it, but the broad principle of law is that law sets out the social norms to the extent what is unacceptable to civil society, unacceptable to constitution, unacceptable to international conventions, for example, CEDAW, unacceptable to civil society. And this is what the law does. So my belief is, generally speaking, law does put down the norm and puts down what is black and what is white and what is gray. So therefore, this kind of area would probably be defined as something which is black and therefore an area within which it can't survive. Something has to be defined. This definition of law is something that needs to happen so that a standard is set, the norms are set, that this is an offense. However, how many cases come to the open, it takes its own time. You had 498A, for example, cruelty against women. It took quite a while before women actually started engaging in the process of dowry harassment and physical harassment and cruelty, which came to the courts. So today you do have a situation where women are coming up fairly consciously and fairly easily. A similar situation would be found with any kind of offense which is made in this respect. But as I said, at the end of the day, it is an issue which the woman has to decide whether she would like to make a case or not. And we also must tread carefully. There cannot be a compulsory imposition on anybody to do so. You can have the option and you have to have the law enable. The law has to be enabling, not compulsive.
All right. Thank you very much, Ms. Pinky Anand, for joining us here on Urban Debate on Mirror Now this evening. All eyes will be on the hearing in Delhi High Court on this very, very important matter that is expected to resume tomorrow. And we'll see what the centre really has to say on this matter. Thank you for joining us. With this, we will slip into another very, very short break. There's lots lined up for you on the other side as well. Stay with us.